Good morning, everyone. I'm Hannah Wheater, a social media and digital marketing executive from HR Toolkit, and I just want to welcome everyone to today's webinar. For those of you who are new to us, HR Toolkit provides HR software, and we run an ongoing programme of webinars covering a variety of HR and business topics. Today, we are looking at how to prevent discrimination and protect your business. And we're going to look into how discrimination can occur in businesses, how to anticipate and prevent discrimination, and how to protect your business from discrimination claims. Following the presentation today, which will last around 30 minutes, we'll have time to answer any questions in the Q&A section. Please do put any questions as we go on in this presentation today in the Q&A box instead of the chat. If you do want to just wiggle your mouse and just see that Q&A box, please make sure you put your questions in that box there. We also do have the Zoom chat, so if you do have anything to participate with, please do get involved, but do make sure to put your questions in the Q&A chat. And just a note, today's webinar is offering general and not legal advice, and our next webinar will be looking at how to onboard new employees for your small business. If you are interested in that webinar, I'll be putting the invitation link in the chat as we go along today. But here to introduce how to prevent discrimination in your business is Toby Pochron. Toby's a senior associate at Freeths LLP Employment Law in the Employment Law department, and I'll take it over to you, Toby. I'll just stop sharing my screen.
Thank you, Hannah. That's a lovely introduction. So I will just start sharing mine to bring up the presentation. Right. So good morning, everybody. Yes, following that lovely introduction from Hannah. So my name is Toby Pochron. I'm an employment law solicitor with Freeths. So a bit about my background. I started off my legal life as a trade union solicitor. And then over the course of the last sort of 8 years or so, I've been doing corporate law. So helping businesses to avoid pretty much this, help to avoid discrimination claims, help to manage those claims when they come in, and look at the potential liabilities that come out of it. So today's webinar is called How to Prevent Discrimination and to Protect Your Business. To give you a brief overview about what we're going to be going through, I'll be talking initially about what discrimination actually is. So the core aspects of discrimination, how you're aware of them, and then we're going to look at how businesses can be liable for the actions of their employees. That's what's known as vicarious liability. And then the positive actions that employers can take in order to support disadvantaged groups within their workforce. And then latterly, how to protect your business. So core practical steps that every single business can take in order to not only reduce discrimination from occurring, but also to potentially avoid any liability should it be alleged in the future. You'll see from a lot of this, it's always an interesting kind of balance to draw, really, because what we as practitioners for employment lawyers want to do, we want to see a business take proactive steps to prevent discrimination. Not only is that good for the business, it's also just good morally and socially. Discrimination in any form, inherently is abhorrent. And what we want to see is that every single employer is taking that step in order to avoid it. However, if it does occur, it's the steps that an employer can take to ensure that they've done what they can to avoid any liability that pops out. Just saw Marie pop up as well. Hi, Marie. I'm going to move on to the core fundamentals of what my talk is going to be about. So I'm going to start off with what discrimination is. So the discrimination law itself comes from a single piece of legislation called the Equality Act 2010. Now there are bags of other pieces of litigation that have fed into the Equality Act. The Equality Act is always changing, but what I'm going to be referring to here is the core piece of legislation. Right, Hannah's just said that you can't see my presentation, so let me just check that that's right. Can you see my presentation now? Is that all up there now?
That's perfect. I can see it now. I think it might have just not gone through.
I think I was sharing the screen that I was on, but here we go. Right. So discrimination, lovely stuff. Thank you for letting me know about that technical problem. So discrimination itself, we've got 9 protected characteristics that form the substance of discrimination.
Sorry to interrupt you, Tip. I still can't see your screen. I might just have to share my settings. You just press that green button, share screen, and then click the desktop or presentation.
Yeah, so I got that one. And then we'll click share.
Perfect, that's great. You can't have a webinar without some technical issues, eh?
Yeah. I mean, I can see the slides and they're brilliant. So, I mean, I'm sure you guys will love them when you can see them. Is that, oh, here we go. I'm jumping forward. Is that better?
That's brilliant. I can see them.
Amazing. Now. Do you know, I said this to Hannah when we first started off, to my absolute shame, I've done so many webinars over the course of the pandemic. I've never had to share my own screen. So if I've just had someone behind the scenes clicking through it for me, and then my very first time I don't even share them. So cheers, thank you very much for letting me know. Any further problems, please do jump on. So what the Equality Act does, it sets out 9 protected characteristics that are protected under discrimination legislation. It is only these 9, right? So it's age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion and belief, sex and sexual orientation. Those are what Parliament have said are requiring protection under discrimination legislation. If a allegation comes from an employee and it is outside of the 9 core protected characteristics, then it is not subject to protection under discrimination legislation. Probably the core one that we've seen develop over the last few years has been caste discrimination. So that would be different parts within social society, especially within Asian cultures, that has come out as part of race discrimination as well. But we haven't really seen those aspects develop too much. It stayed as this core set of 9. Now, over the course of my sort of, I guess, 10, 11 years of practice, I've seen every single type of discrimination come up. So I've seen each one of these be alleged at some point in time by an employee. Now, discrimination claims themselves, I see them lots because I'm an employment lawyer. They are common. They're common because a lot of times what's happening, and certainly within the pandemic, is that allegations are made by an employee about something that they've suffered. And where someone can't quite join the dots about the treatment that they have suffered, they'll generally say, well, I think this is due to some sort of protected characteristic that I've got. You know, and it can be a simple case of my employer doesn't really like me. You know, my employer didn't want to develop me for whatever reason, but also they can say, well, actually, you know, I'm of a different race. I've got a disability. I'm slightly old. I'm too young for that organization. And I got the feeling that they didn't like me because of this protected characteristic. And oftentimes the claims that we see brought are just advanced on that basis, just with that bare kind of allegation of, and I think this is because of my race, and I think that I was dismissed because I've got a different religion or belief, or I think that I was terminated because of my disability. That's all an employee needs to do. You know, to advance that claim, they just simply need to put that set of words in on an ET1 to an employment tribunal claim form and submit it to an employment tribunal. And that will get carried through to final hearing. There's a public policy in place that discrimination claims are incredibly serious. And equally, they require a judge to look at them to ensure that they are properly disposed of, which means that it can be the case you get this really spurious claim, it's a false claim, it's just simply not going to go anywhere, but it will always reach final hearing, right? They're very, very unlikely that that ever gets struck out and removed from the tribunal list, unless it's completely salacious, you know, unless it's something that is so fundamentally ridiculous as to not warrant a judge's time. But the vast majority of them will always go through to final hearing. That's why kind of prevention is always better than having to deal with that claim. Even if you're successful at the end, you've still had a significant period of upheaval within the business. You've still had a significant period of cost. You know, even if that's not solicitors' fees, you know, even if you do it yourself, there's managerial time that goes into defending those claims. So in essence, it is much better to put procedures in place now. It's a lot cheaper, and it will also help your business out in the long-term term. So I'm going to look at the core aspects of discrimination here, and I've put them up on screen, and I'm glad you can see them. So the first one is direct discrimination. So we've probably all heard the term discrimination used. It is nuanced within the law as to what discrimination actually is. So direct discrimination is when person A is treated less favorably than a person B because of a protected characteristic. It's probably what we call the kind of the classic example of discrimination, really. So for instance, an individual doesn't get a promotion because she's a woman, and instead the job goes to a less qualified man. You know, that's it. You treated someone less favorably than you would treat somebody else because of our protected characteristic. Because she's a woman, she doesn't get that job promotion. Now, that implies a comparative test between two people. So it has to be, I was treated less favorably than somebody else. Now, it's a really difficult claim, really, for an employee to be successful in, because you've got to show either that there was someone who was treated more favorably than you were, But equally, if there isn't that person there, you have to create a hypothetical person. And you say, well, the business would have treated this person better than they treated me. And that, again, it's difficult to get over. It doesn't mean that it won't be alleged. Direct discrimination itself can expand out into different areas too. So there's another type of direct discrimination, and that's called discrimination by association. And that's where the individual who is subject to discrimination isn't discriminated against because of their protected characteristic. They're discriminated against because of somebody else's protected characteristic. So an example of that would be, so Jeff has a close friend who's just gone through gender reassignment surgery. After some of Jeff's work colleagues find out that that's taken place, they stop inviting Jeff to social events. That could be discrimination by association. It's not because Jeff's gone through gender reassignment surgery, one of his colleagues are, and his workmates don't appreciate that. That in essence can be direct discrimination by association as well. There's also a direct discrimination by perception. And that's the classic aspect of that would be where an individual is perceived to have a set of protected characteristics. The most common example you get with that would be bullying of a heterosexual employee, which they show kind of offensive sort of stereotypes towards homosexuality, and their work colleagues subject them to less favourable treatment because of that perception. That, again, isn't a protected characteristic that they have, it's something that their employer or their workmates perceive that they have. And so that's also protected within that too. So that's kind of direct discrimination as its fundamental sort of position. Now, you tend to see that claim alleged, but it is, as I say, very difficult to be successful in. The other aspects of it you tend to see more commonly, it's something called indirect discrimination as well. So indirect discrimination is where a business has what's called a policy, criteria, or practice. So a thing that they do that applies to the entirety of their workforce, but it puts a certain group at a disadvantage. Right? Now, unlike direct discrimination, which can never be justified, indirect discrimination can be justified as long as it's a proportionate means of achieving a legitimate aim. And I know that because I've only got half an hour this morning, quite a lot of these are fairly chunky kind of concepts. I'm just going to give you a practical example of each one to kind of explain my point in a bit more detail. So, for instance, you have a job advert that says that applicants must have 10 years of experience working in a certain sector. So by doing this, by putting that job advert out, it applies to everyone who could come to it, but it puts people without that level of experience at a disadvantage. So probably age discrimination. So it's probably younger people who have been unable to achieve 10 years of experience. They would be treated less favorably. They would be disadvantaged by that job advert from coming out. But the business might say, well, actually, we need that level of experience in order to do this role for some reason. It might be a health and safety reason. It might be a requirement of a contract that they've got with their end client. We need this person with a set level of experience to do that. That could be an indirect discrimination claim, and the business would likely defend that on that basis and say, no, we need this. It's a genuine occupational requirement that we have to have that level of experience. Now, the way to avoid that claim would be to adapt that job advert. Simply say, we need this experience for this job role to be performed. It doesn't necessarily need to be linked to an amount of someone's age, doesn't even necessarily to be linked to an amount of someone's experience in terms of time. If you say to someone, we need you to have this level of experience, that would wipe out that claim completely. Now, that is a really decent way of avoiding those types of claims coming through. But one that we're really commonly seeing at the moment is claims in relation to working full time. So the business requirement to work full time applies to everyone, but it could put female employees at a disadvantage as they're more likely to be the primary caregivers for children and therefore more likely to need to work flexibly or to reduce their hours to work part time. Employers who have a requirement for a certain job role to be done on a full-time basis or not flexibly would need to ensure that they have genuine, real, proportionate business requirements for that. I'm seeing loads of these types of claims at the moment. It's common. You get someone who puts a flexible working request in. They don't get the outcome that they're seeking for it because the business, if they don't do it properly, they just kind of shut down. They say, no, this is a full-time role. It needs to be done full-time. They don't really put their minds to why it needs to be done full-time. And then the very easy allegation is, well, it is simply put, that could be indirect discrimination because you're not thinking about why that needs to be done in a certain way, just simply shutting the shutters on it, and therefore it's not proportionate, it's not legitimate. But by the time that comes to me, all that correspondence has been dealt with. And so the employer has made their decision already. So, no, we're not going to put this in place. So that is then kind of them rowing back and trying to defend an indirect discrimination claim that's come out of it by then using what we're saying here. So say, well, why did that need to be done full time? And then they can explain it. It's much, much better to be able to explain that to an employee, explain that why it can't be done flexibly for whatever reason that would be, why it can't be done part time, to ensure that they also understand that it is legitimate, proportionate, and that you're going to keep that under review. Disability discrimination itself carries two other specific types of discrimination. So every protected characteristic is protected under direct, indirect, harassment, and victimization. It's a little bit separate, so I'll come on to that in a minute. But direct disability discrimination also has two specific areas for it too. So there's an aspect called discrimination arising from a disability. So what that does, that's where someone is treated unfavorably because of something that arises as a consequence of their disability. So the common example that you see from this would be someone with anxiety and depression. This is obviously just an example. Someone with anxiety and depression who takes time off work. They take time off work and they are then subject to a disciplinary for their high level of absence. Now, they're not being subject to a disciplinary because they've got anxiety and depression. They're being subject to a disciplinary because they took time off. But if that time off arises out of their disability, then that will be discriminatory conduct on behalf of the business. So it's a level to sort of balance that out, to say, well, is something a symptom of a disability? Does that also require protection too? But again, unlike direct discrimination, it can't be justified. Discrimination arising from a disability can be justified by a business as long as, again, it's a proportionate means of achieving a legitimate aim. So stability within a workforce in terms of having people not have too much time off work, that would be something that would allow you to take into account disability-related absence when considering whether or not someone should go through a disability, should go through a disciplinary. Now, again, that's all well and good, but it's got to have that balance role to it. But again, those types of areas, those aspects for employees, they are inherently tricky to manage too. I could probably go and do a full couple of hours worth of presentation on just disability discrimination, but that's the key point for that. So there's also a failure to make reasonable adjustments claim. So where a provision, criterion, or policy or physical feature of a business puts an employee who has a disability at a disadvantage, the employer has to reasonably adjust their working practices or their workplace in order to remove any barriers that individual would suffer in being able to attend at work. Designed as a sort of social policy aim to stop there being a barrier and to have an employer have a positive obligation to remove those barriers where it would be reasonable. Reasonable adjustments, there are absolutely loads of them. The common ones that you kind of see are adjusting working times, adjusting policies so that it's not so critical of people who have got disabilities, putting physical aids in place, different types of mouse and larger screens, having everything printed out for an individual, having them buddies to help them out with doing their work. There are tons of those. But again, that's a positive obligation on a business to avoid that. And again, if you've got someone who has a disability, at the point when you are recognizing that disability or they've told you about it, that's when you've got a positive obligation to take some sort of steps to act in a certain way. And at that point, that if you don't take that step, there's a failure to make a reasonable adjustment, as long as the adjustment is reasonable. But reasonable depends on the size of the business and what the adjustment would be. So for instance, I had one where it was a requirement, an individual was requiring there to be a lift in the premises, and it was going to cost a small employer about 20 grand to put that lift in. That wouldn't have been a reasonable adjustment for that employer, because they wouldn't have been able to afford that. But equally, if that was someone like O2 or Virgin Media, 20 grand would be nothing to them. Or in this respect, so the law would imply that it was nothing to them, and they will be required to put that in place at that point in time. Obviously, there's shades of grey with that argument too. Another aspect of discrimination is called harassment. Again, harassment really commonly kind of a term that's used by employees. Harassment itself is covered. It's unwanted conduct that relates to a protected characteristic or unwanted conduct of a sexual nature that has the purpose or effect of violating someone's dignity, creating an intimidating, hostile, degrading, or offensive environment for them. So the key aspects, just to pick up on those ones, it has to be unwanted conduct. So this is really common in kind of banter kind of arguments. So people who engage in sort of a friendly banter back and forward, probably a bit offensive, might be related to a protected characteristic. That wouldn't be harassment because it was wanted by both parties. that banter in and of itself is inherently tricky for businesses, because you don't want your employees to work in a vacuum, but equally, when something tips over into being offensive or unwanted conduct, a claim can kick in, even if the conduct has been wanted all the way up until that point. So the example I've got from a bit of case law was there was a couple, a man and a woman, who engaged kind of overtly sexual remarks to each other throughout the entirety of their working lives. Both wanted conduct all the way through, but then eventually in a meeting, the guy drops his trousers, gets his bum out, and asks the woman to smack him on his butt, right? At that point, she brings a claim and says that that was the unwanted conduct. That was the step too far. That was the straw that broke the camel's back. And even though, and the business defended this, obviously, but even though there was this kind of ongoing, kind of underlying wanted conduct all the way through, as soon as it becomes unwanted, that's when the claim kicks in. But also, it only takes into account the subjective views of the person who is the victim. So if the individual who's undertaking the harassment didn't have the consideration that they wanted to cause that person harm, they wanted to upset that person, then that doesn't really matter, because it's whether or not the conduct itself has the purpose or effect, the cause, purpose or effect of creating that environment. So it can be intended to be harassment, it could be completely unintended, but it's only whether or not the individual who's suffering it wanted that to take place, or whether or not it's unwanted, and that's when that aspect kicks into. And very finally, there is a kind of this protection that is put across for employees where they've done something that relates to the Equality Act. That's called victimization. So again, victimization is a really commonly used term. It's not normally used correctly. People say, I'm being victimized, I'm the victim in this scenario. But victimization under the Equality Act is where the individual does a protected act. So a protected act is either making a claim under the Equality Act, assisting somebody else in making a claim, making an allegation that the employer has had a contravention of the Equality Act as well. Those would all be protected things that an employee does. If the employee suffers a detriment, so something that they would think was less favourable to them or treats them poorly, then they can be protected under that legislation. And they can be protected from being subjected to something that is on the basis of their protected act that treats them in a detrimental fashion. So that covers off kind of the main aspects of what discrimination is. So I'm just going to jump over to my next slide, which is how a business can become liable for the actions of its employees. So an employer can be held responsible for the actions of their employees if they engage in discrimination, and that's what's known as vicarious liability, which is the title of that slide there. Now, there is an equal balance in an employment tribunal between personal liability for the individual who undertakes the harassment or the discrimination and the liability of the business. What you generally see in practice is where there's a discrimination claim that's brought, the employee will bring a claim, the individual will bring a claim both against the employer and an individual that they say was had the conduct of discrimination against them. And the reason for that is that an employer can avoid liability if they've shown that they've taken all reasonable and necessary steps in order to prevent discrimination from occurring in their workplace. So just look at this in a little bit more detail here. So in terms of whether an employee or employer are both held responsible for actions, this depends on whether or not discrimination was linked to the employee's work. So the Equality Act describes that where an individual acts in the course of their employment, then that's sufficient enough to link it to being the employer's responsibility, and an act that therefore is done by the employer. So an employer, a company, it's passive in itself, but it acts by its employees, it acts by its officers. So what the Equality Act says is if your employees engage in this, then you're liable for their conduct during the period of their employment with you. So that can also extend to things outside of work, work-related parties, or social media accounts that are linked to work as well. All those things can bring a liability back to the employer, but also the individual as well. Now, again, the employer can avoid liability here as long as it's shown that it's taken all reasonable steps to prevent discrimination from taking place. It's what's known colloquially as the reasonable steps defense. So to give you an example of this, you've got Gary and Bill, right? They work in the same team. The company takes initial preliminary steps. It trains and it tests its staff on equality, diversity, and discrimination. right? So it sets that up. It's got a strict policy in place. It's told all of its employees about its policy. It reiterates that policy to them on a regular basis. And I've just said it also trains and encourages them to do any type of reporting too, right? Gary sends Bill an offensive message in work, sexually suggestive emails, okay? Bill complains to his line manager. The company takes the steps that are reasonable. It immediately suspends Gary and accesses his email account. It immediately investigates this and takes it very seriously. Following the disciplinary, Gary is given a final written warning. For instance, it takes a reasonable disciplinary step against the individual who's accused of the harassment and is found guilty of that harassment, and then sends him on further equality and diversity training course. Now, that won't stop, those actions won't stop Bill from bringing his claim. So Bill will then bring a claim against both the employer and the employee. But what the employer will be able to say is, well, this is Gary all by himself. You know, he's done this under his own wit. It's not something that we can be liable for because we've done everything we possibly can in order to avoid that discrimination from taking place. Training, policies, regular review, you know, taking immediate action, immediately investigating, taking appropriate disciplinary action. All these are the reasonable steps that an employer can take, and that's both pre and post an allegation of discrimination being made. So employers can also undertake what's called positive action as well. So positive action allows an employer to take certain actions in order to redress a balance when it's all at place about any individuals who might be disproportionately underrepresented or may have particular needs. So general positive action allows you to assess whether or not there's a certain characteristic or a certain category of employee within your workforce who are, say, underrepresented disproportionately, or who have a certain positive requirement that you need in order to advance them appropriately. So looking kind of at this positive action, recruitment and promotion, that's probably the most common one. It'd be where you had, say, individuals who are coming to you. There's a spread of individuals, all of different races, who are all equally qualified. Positive action in recruitment allows you to address your workforce and decide whether or not you believe that you have a certain underrepresented group, and about whether or not encouraging the recruitment of a certain category of employee, a certain characteristic, would be beneficial for your business. That then allows you to take a positive action step to recruit from that group, even where you had others who didn't have that characteristic there. So the examples of positive action here would be, say, a police service who has a disproportionately low number of people from an ethnic minority background, identifies a number of candidates who are qualified as each other for recruitment into a post. So that might include a candidate from an underrepresented ethnic minority background. And here it would not be unlawful to give preferential treatment to that candidate, provided that there was a comparative exercise and all the other candidates' measures and whether or not they were qualified in the same way was also taken into account. You can also see this where an employer is faced with choosing from 3 candidates, all of equal merit, where one has a mobility impairment, one has a learning difficulty, and one has no form of disability at all. In order to address underrepresentation of people with learning disabilities within its business, an employer can decide to select the candidate who does have a learning difficulty, and that would not then amount to unlawful discrimination against either of the other 2 candidates. Examples of sort of general positive action you can take would be to say things like, you know, recruitment exercise. We encourage female applicants to apply. We encourage those from different ethnic minorities to apply. That's generally enough to sort of get you that kind of positive action criterion, as long as you've done a prior assessment about your workforce and decide that actually that's pretty necessary to develop that as part of a recruitment exercise that are going through. That can mean, you know, kind of outreach days in certain aspects of the community, open days, training events, you know, getting more involved in community activities. Those are good aspects for, you know, a general positive action that business can take to address any issues within the business about underrepresentation or whether or not someone's disproportionately being recruited in a set way. Now, protecting your business. So I noticed that I'm coming kind of close to my time here. So what I'm going to be running through now, in this very final part of my slide, is some core kind of practical steps that business can take in order to protect the business and also to avoid discrimination claims from coming through. So recruitment, again, It's always seems funny because I wouldn't have thought kind of in the area that we're in that job adverts would cause employers so much problem, but they still do. You know, people still put out job adverts with either non-gender neutral terms on it, with requirements for a number of years worth of experience that can then be age discriminatory. You know, it's thinking about initially what your business needs and then setting that out in a job advert and just having someone read through that is really quite valuable. So I've also had it where there's been kind of a legacy term that's been used in a business. The common one I found was like it was like a floor girl or an office girl. You know, it's someone who's designated into a certain role, but because of their gender, they're given a certain job title. That can just be legacy. You know, it can be something that an older business that you've acquired for say 40 years has used that term, but no one's quite updated it. So it's then colloquially used throughout the business, and someone's then in essence seen that as a pejorative term that's used for them that's inherently related to their gender. That in a business can be completely, it's not designed to be something that's offensive. It's just an old term that's been used, but no one's ever challenged the people who have been in the business for a long period of time about the use of that term. And it can just be having a policy in place that prevents that from being used and making sure that that doesn't, you know, cover over into the job adverts that are used or the terms that people use when they're going through a recruitment exercise. So when you've got a characteristic that you need for your business, so something like a recent graduate or someone that's highly experienced in a certain area, though those two terms, again, potentially based on age, they need to be actual job requirements. So what you should always be considering when you put those type of roles out is, well, do we need that? You know, why do we need that? Is it an obvious criterion that's there for us? Is it a genuine business need? Are we justified in taking that step? Do we want someone who's highly experienced just because it'd be genuinely nice to have someone who's highly experienced? Have we considered whether or not this has a potential discriminatory impact? I act for a large national coffee chain. They have ongoing issues that come about with this, especially within recruitment, because you see people who apply for job roles who don't really intend on getting the job. You know, they're applying for roles as a means to bring these types of claims to say, well, you've done this, I think that's discriminatory. And in essence, I don't really want you to recruit me. I'm just going to now challenge you about why I didn't get that job role. And so, you know, having a restriction on those types of statements that are made can reduce that type of claim coming through. It can reduce those people who are just kind of looking for aggravation or looking to bring that claim because they didn't get the job role that they put forward for them. We always make sure that candidates are treated the same throughout any recruitment exercise. So we make sure there's a standard list of questions. Everyone's asked the exact same thing. You know, you can engage in kind of this job screening exercise, which larger employers tend to do as well. You have one group of people who anonymize any requirements from a CV. So say you get a CV in with a job application on it, they're completely anonymized so that it is simply that person saying, yep, this person's good enough for the job role. And then that gets passed on to the second stage. The second stage interviewer then doesn't know any of the particular characteristics about that individual, doesn't know kind of their ethnic background that might come out of their name, doesn't know anything about their age or where they went to school. They just know that somebody else has said, yeah, this person's good enough to do the job role, and that then kicks it in. That can go away as ways to avoiding what's called subconscious bias. So where someone takes a decision, they're not intending to be discriminatory, they just think in a certain way. That in recruitment, it is very, very tricky to manage, but it's something that you see more often, certainly in public sector as well. They're taking steps to avoid those types of claims kind of coming through. But what smaller employers, what SMEs can ensure that they do is make sure that their recruitment exercise is completely consistent. Everyone's asked the exact same questions, and we don't ask questions. And again, it sounds, you know, to just suck eggs. We don't say things like, are you planning to have children? Are you planning to start a family? Is your family complete? You know, are you married? You know, do you have a disability? You know, at those stages, you don't want to be seeing those questions coming through, because it's something that if someone doesn't get the job role, they can then join two dots that might not need to be joined and then advance that claim to. Now, equal opportunities policies are something that I always advise for every single business. If you have an equal opportunities policy, you've put equality and diversity at the core of your business. You're saying to your employees and to anyone else who chooses to ask for it, that you've taken the decision to put that procedure in place. You're taking the time to put it in there and have it tailored to your business. What's appropriate within that policy itself, determining what harassment and discrimination are, determining what victimization is, telling employees what is and what is not acceptable conduct throughout the workplace, giving a complaint and a reporting procedure for staff so that they can put those complaints to you swiftly and that they know they're not going to suffer any retaliation for doing so. They set out for employees the foundation of what is a safe and respectful workforce. And that can significantly reduce not only individuals who do then engage in discrimination, just gives them that pause for thought to think about the actions that they're taking, but also then, as I say, can help with the reasonable steps defense later on. Equal opportunities policies, they can be as broad as they are long. I prefer having them really detailed and really set out. When any new starter joined, we send them that policy. They know that's on the map when they first join. It's then regularly reviewed, regularly reissued. I put later on in this education and training, which is my next point, making an equality champion. Having someone in the business who has the ability to challenge the business about how they are going to positively tackle discrimination. Equal opportunities policy, equality champion, someone who's bringing that in and then regularly reviewing that, having an equality day, making sure that everyone understands that their obligations, as well as social and moral obligations towards preventing discrimination from taking place. And that fits in really nicely to education and training. If you don't train your staff on how to avoid discrimination or how to notice it from happening within the business, you can be liable for a claim. As I said before, I always talk about liability for claims because that's the end what we deal with. We want to avoid that from taking place. Having equality and diversity training in place goes some ways to avoid that from ever happening in circumstances as well. You also want to make sure that you deal with any allegations swiftly and you deal with them efficiently as well. Dealing with them swiftly and efficiently not only gives the individual who's raised the complaint security, it also allows you to reduce upheaval to your business. These are incredibly difficult to deal with. I do sex harassment investigations for clients. Generally, I'm kind of dropped in there by like a firm of accountants, so I'm completely kind of independent, and they let me just interview whoever I choose. Employers will find that aspect difficult because they've got a duty of care to everybody. They've got a duty of care not only to the individual who's the victim, who's made the allegation, but a duty of care to the individual who's had the allegation raised against them. So there's a balancing exercise between those two aspects too. So you don't want to move, to suspend that person, remove them from the job role, get them out, make sure that we've proven them guilty before they're proven innocent. That aspect would void a duty of care towards the individual who had the allegation raised against them. But if you've got a policy in place that says what we're going to do is we're going to get the allegation in, the first step we'll take is meet with you immediately. That'll be within a day of you raising your complaint. We'll get the information from you. We'll then talk to you about what steps we're going to take, whether that be a covert investigation, see if you can do that covertly, whether or not suspension is necessary for that other individual, and talk to you about the policies and the discretions that we're going to use when that comes into us and how we're going to take that account. Did the incident happen, many years ago? It can be that just harassment claims certainly are raised much later in the time. How are we going to deal with that? If it's raised historically, we're probably not going to end up suspending that other individual because we've allowed them to work throughout that time. However, if it happened 2 days ago and it's something that's gone beyond just words being used, actual physical assault, that allows us to suspend, and we'll take that step at that point. But if you have that all set out in a policy, everyone knows what's going to happen, but B, you can then follow it. So a manager who might not have gone through a sex harassment investigation or any type of discrimination complaint in the past, then has the comfort that they know exactly what steps to take at that point. Now, I always say at the end here as well, it's always good taking legal advice, especially when these types of claims come in or when these types of allegations are raised. And it can be that you have these little trigger points that come through. So advice from us, advice from a HR provider that you use, it's always going to be invaluable because it's going to give you the ability to have comfort about the steps you're taking, because the allegations that employees raise aren't always completely overt. You do see them where they say, I have been subject to discrimination, I have been subjected to harassment, but sometimes you can have them come through and they can just be a bit kind of layered in there. Actually, I wasn't allowed to take time off for this appointment. I needed this medical appointment because of my disability or because I've got anxiety. And then that's something just in an email to their employer, maybe that manager doesn't pick up that that was something that's arisen out of a disability. Maybe they don't pick up that they now have a duty to make reasonable adjustments for that individual, and that gets left. But then that gets put in front of a judge, and when the claim gets brought for disability discrimination, the employee says, I told you that's what I needed. I told you I had a disability. I said I got anxiety. I told you that I needed these appointments, and you refused them anyway. You didn't adjust my work well as you're supposed to, and that's taken into account that something that arises out of my disability is a need to go on these appointments regularly and at the times when they're set for me by my doctor. That can be discrimination that individual just simply, the individual manager just simply didn't appreciate at that point. So it's always worthwhile taking advice as and when they come through, but having these policies and procedures in place, solid recruitment policies, solid equal opportunities policies, solid education and training, putting procedures in place to make sure that everyone knows exactly what's going to happen, and putting in place an equality champion. These are all things that help you avoid those types of discrimination claims that come into your business too. That is it. So that is a real whistle-stop tour. I have gone over, so I do apologise, but I think we've now got some time for some questions, because I've been banging on and because my screen's just right above me, I haven't seen if any have actually come in. So what I'll do, I will stop my share now and kick it back to Hannah.
Amazing. Thank you so much, Toby. I really appreciate everything that you said then. I think that it is a topic that can open a can of worms, and it's not something that can be described really quickly, but you were amazing at describing that. And so thank you. We have had some questions come through whilst you were speaking, but just a reminder to everyone again, please do make sure if you have any questions for Toby, please do just put them in the Q&A box there. We do, just before we go on to the questions, have a quick poll we'd like everyone to just have a look at. This simple sort of question, some feedback for us, and as we've got loads of small business owners and HR professionals on the call today, we'd love to get some feedback from everyone here. So the question is, what is your organisation's biggest challenge when it comes to HR? I'll leave that in there just 2 minutes whilst we wait for everyone to put in their answers, and shortly after I will get on to the questions. If you have answered that poll there, please do think of any questions for the remainder of this webinar. That'd be fantastic. I know there's a few questions coming in now, which is great.
Says I can't vote.
Fantastic.
This is
oh, can you not?
It says host and panelists can't vote.
Must be a privilege for attendees. That's great. I'll end that poll now. We've got some great feedback. Thank you very much. That's fantastic. I'll share the results. And there are many different results. We've got lots of managing holidays, performance, employee performance, particularly managing training and development. That's fantastic. Great insight for us to have a look at and use in the future. I'll move on to the questions here. The first cap, Toby, you may
what was that? Sorry, Hannah. Sorry, you broke up there.
No worries. The first question is, what were the 9 protected characteristics again, please?
Yeah, no problem. So they are age, disability, gender reassignment, marriage/civil partnership, pregnancy and maternity, race also includes ethnic and national origin, religion and belief, sex, and sexual orientation.
That's amazing. That's a great test as well. That's fantastic. I hope that's answered your question there. If you do have any questions, please do put them in the Q&A box as well. We do have one question here from June. June asks, there is a lot of attention being paid to menopause and legislation at the moment. Is it likely if past menopause could be a separate characteristic, or would that fall under a characteristic?
Yeah, I don't think that menopause will receive its own protected characteristic under the Equality Act. I think it's much more likely that will just come under sex discrimination. or indirect discrimination, they don't often change protected characteristics, mainly because what will happen is the tribunals will infer about whether or not something is included within a certain characteristic already. If it's not, then they will simply pass it back out to Parliament and say, well, if this was important enough, Parliament would take a step to legislate on it. So I can see, from there is other legislation that's coming in respect of menopause. There's been a lot of work that employers have done around having policies in place to manage that within their business and to ensure there is that kind of visibility of it. I don't think it's going to bleed into being Equality Act or becoming part of the protected characteristics just as yet. They as I said before, my talk, the caste discrimination has been one that's been on the radar for quite a long time, and then that was determined as being part of race. Another one that I've seen is social status. That might be one that's coming in, but again, it's probably going to fit somebody else into another characteristic. Veganism was one that came out as well. That was part of religion and belief. So where they fit into something, the tribunal's quite liberal with it, and they'll generally try and infer it into one of the protections that already exists, rather than asking for it to be fully legislated on.
That's great. That's fantastic. Thank you. That's answered your question, June. We've just had another question come in. And the question is, does your employee need to inform you of his or her disability when he or she joins the company?
So short answer is no. Section 60 of the Equality Act says that an employer can only ask questions about disabilities or medical conditions where they relate to the occupational requirements of the role. So you see a lot of businesses use equality questionnaires, like health questionnaires. Those are unlawful unless they actually relate to the job that's being done. So you can do it on an anonymized basis to make sure that you retain that data, as long as it is completely anonymized and never used against that individual. But broadly put, no, they don't have to tell you. If they want you to adapt their workplace or make reasonable adjustments for them, then they would need to make that disclosure to you in some respect. But equally, you can't be liable for any act of discrimination about a protected characteristic that you don't know about. So if that individual later on would say to you, well, I needed a reasonable adjustment and you didn't give it to me, as long as they couldn't show that you were reasonably aware of their disability, then if they haven't expressly told you, then you wouldn't be liable at that point in time. It's, we want to encourage openness and make sure people tell us about their health so that we can deal with it. The common ones like mental health issues, people who just don't make that disclosure to us early on enough to allow us to ask an employer to assist. But no, so a bit of a long answer to your question there, but no, they don't have to tell you. There's no formal requirement on them to disclose. They can refuse to disclose if you ask them as well, but I would only ever ask them if it was a genuine occupational requirement, or you encourage them in a period of openness to tell us what adjustments they may need or anything that we need to take account of.
That's great. We haven't got any open questions at the minute. If you do have any questions you want to ask Toby before the end of today's webinar, please do make sure you put that in the Q&A box. I'll just quickly wait a minute. No, I think that's great. That's fantastic, Toby. I know our internet might be a bit glitchy, but what would a webinar be without that? So that's fantastic. I just want to say from everyone also watching, Toby, just thank you so much for today's webinar. I definitely found it really informative, and I'm sure everyone else did, with a lot of great feedback in the chat as well. And just a reminder for all the other attendees, if you would like to attend our upcoming webinar on the 22nd of September about onboarding new employees for your small business, please do click the link I've put in the chat. I will put another link in the chat there as well for anyone else that wants to attend that webinar. But thank you very much, Toby. I hope everyone's enjoyed today's webinar, and I'll see you all soon.